Okay, do we think we are online, live, here in the room, present, functioning, and on time? Good. Okay, so I'm going to say welcome. I'm Sonia Livingstone, and it's a pleasure to welcome you on behalf of the Digital Futures for Children Centre, the Department of Media and Communications, LSE, and the Five Rights Foundation. And we're here to discuss the question which we have been wondering about for some time now, which is, does online regulation work for children? How do we account for child rights impact in the new regulatory era? The Digital Futures for Children Centre at the Department of Media and Communications, LSE, is jointly with the Five Rights Foundation, and we exist to support an evidence base for advocacy to facilitate dialogue between academics and policymakers and to amplify children's voices. And today's topic seems very timely, once a little nerdy, but now quite of the minute, right? Because calls for better regulation of digital companies have gone global. Public policymakers, politicians, parents, and children are all calling for urgent improvements. And there's a lot of evidence that those of us in the social sciences are developing to say why. I mean, one result I could give you from what is really now a mounting evidence of online harm from the EU Kids Online Network, which is just about to publish its new survey of 29,000 European children, shows a sharp drop in safety. Half of the children now say they do not feel safe online. And since our surveys, since 2010, the proportion that have seen self-harm content, eating disorder content, suicide content online have all gone up. So, as you will know, many countries around the world, one more every day, are proposing to ban children from social media because the social media business model prioritizes profit over children's best interests. And it achieves this through maximizing and holding children's attention and collecting their data. So I think everyone agrees something must be done. And however we rephrase a ban, perhaps as a delay or restricting the way in which digital services reach children, the effect is would be in part to limit children's digital freedoms. So this is another part of the puzzle that we are worrying about. And that same EU Kids Online survey shows that children actually do lots of positive things online, including on social media. So our survey shows children's number one online activity is communicating with friends, followed by watching videos, listening to music, and communicating with their parents, and even sometimes doing schoolwork online. So restricting children's access to social media has lots of adverse consequences as well as possible benefits. So we are looking for something that can be done that would be better, and something better is being done. What is that something better? Many countries around the world are also, and over a longer time scale, passing legislation to keep children safe online, to design in safety by design, as well as privacy by design. We have an Online Safety Act in the UK, in Ireland, in Australia, the Digital Services Act in Europe, the UK's Age Appropriate Design Code, and most recently, the ECA Digital in Brazil. And many more countries are also debating what can be done. So today we're asking a crucial question, which is, how are we as a society regulating digital companies? Are we regulating them effectively? Are we managing to mitigate those risks of harm? Can we keep the regulation up to date now that so many children are also using AI and new risks seem to arrive on our agenda every day? And even, can we design the regulation in ways that positively respects and realizes children's rights online, which is a crucial question, very much on our minds. So I think a lot of countries have been debating and formulating regulation. And platforms have new duties, regulators have new powers. There's a lot of expectation, a lot of questions about what is working. But there's also the big challenge of implementation and enforcement. And that is also tough. So how is the regulation going? How is it working? The DFC first commissioned Steve Wood, who is sitting here, to review the impact of regulation on children's digital lives in 2004, and particularly focusing on the UK and Europe. And he'll say a little about what we then framed as cautiously optimistic research findings, which did seem to have driven a step change in business practices by encouraging more safety and privacy services used by children. Last year, we invited the new report that we are launching today, asking whether further improvements are occurring as regulation widens its reach, and also as company practices continue to evolve. We focused on the UK as a case study and as a way of kind of focusing the research, but we hope the messages go wider. And in a minute, I'm going to ask you to explain what platforms are doing to improve their services in the face of mounting evidence of harm. So the plan for the evening is that we're going to hear a short report on a short presentation of the report and its findings. Then we're going to hear 5 minutes each from 3 very stellar respondents with some very distinctive expertise in the field. We'll have a bit of a discussion among the panel who will come and sit here. And then we're going to open up to the audience, both in the room and also online. We will conclude at 8 p.m. And for those here present, we have a reception outside this room afterwards. So let me introduce our speakers. And Steve Wood is former UK Deputy Information Commissioner and chair of the OECD Working Party on Data Governance and Privacy. And he's founded Privacy X Consulting to advise on data protection, online safety and digital regulation. And he's a senior visiting fellow at LSE and the DFC. Once Steve has done his presentation, we're going to hear from Professor Lorna Woods, OBE, who is Emeritus Professor of Internet Law at the University of Essex and a leading expert in online safety, platform regulation and digital governance, widely known for helping to shape the UK's duty of care approach to regulating social media. Professor Orla Linsky is Chair of Law and Technology at UCL Laws and visiting professor at the College of Europe and was previously here, so we miss her. And her current research focuses on the coherence and effectiveness of digital regulation, with particular attention to data protection and digital rights. And we'll hear third from Baroness Viva Kindred, OBE, who is chair of the DFC Management Committee, visiting professor of practice at LSE, and founder and founder of the Five Rights Foundation. She's a crossbench peer in the House of Lords and a world-renowned advocate for children's rights in the digital world. So, Steve, your PowerPoint is up, and I pass to you.
Thank you very much. First of all, a big thank you to the Centre for Digital Futures for Children for funding this research, and also the fact actually I started this journey when I started on the first project in October 2023. So nearly 3 years sort of continually thinking about this problem, and it's been a great privilege actually to be able to do this over a long period of time. So hopefully it may be something we'll touch on later when thinking about the importance of research in this area and what else we need to do. But I think the ability to be able to come back to these questions and map and log these changes and analyze them over time is really important. So thank you for the opportunity to do that. Yeah, so I'm talking about phase 2 of this research today. If you want to find out about phase 1, the report is still on our website. And as Sonia briefly hinted at, the first phase of the research looked at the period actually from 2017 to 2014. So from 2017, really from the inception of the ideas and policy formulations for online safety, and also age-appropriate design, codes, etc., in context of privacy. So we looked at the changes over that period, and we actually particularly focused as well on the changes on Meta, Google, TikTok, and Snapchat during that period. What we were able to do was illustrate by categorizing those changes actually how we saw a linkage between regulation and a shift towards what we call by default protections. So those are proactive measures that platforms implement, like autoplay being switched off by default, to protect children online. And obviously a number of these pieces of regulation, like the ADC, the Age Appropriate Design Code, the Online Safety Act, and the Digital Services Act, all point towards the importance of safety by design in this proactive step. So in the first report, we were a bit glass half full. We pointed to where there's still lots of work to do, a risk still existed online. As well, we could see the early impacts of regulation. So it's in that context, therefore, that we return to the topic, and I'm going to talk about phase 2 of the research today. And just got slides. Frozen. There we go. Go with the mouse. There we go. Thank you. Not going to talk about this in great detail, but it's just, I think, to probably picking up on what Sonia talked about as well. That all of these different developments were actually happening whilst I was working on this project really from October of last year up until now. So there's been such a plethora of announcements, policy debates, new announcements by platforms, court cases, etc. And I've tried to capture some of this in the research. So either my research can help inform some of these debates, or we've actually captured information about some of these developments and tried to categorize and analyze them. But I say as well, there's some days where I said, not another announcement, please don't give me any more announcements, because I've got to stop categorizing and cataloging them all for the project. And indeed, you may read the report later and say, why isn't that change in there? Because obviously I had a cutoff point as well. And then things happened in April, even when I finished that data analysis. But that's just to really set the scene of all of the things which I'm sure many of you are aware, consultations on bans, lots of court cases, new developments from that. Well, so just to talk a little bit, therefore, about the research aim, and then I'll talk a little bit just about the research methods I use very, very briefly, and there's more detail about that. Obviously, the research aim is to examine the impacts and benefits, regulatory measures on online privacy and safety. And it's important we're looking at both privacy and safety. And obviously, the two concepts are very closely related. Obviously, a link about how children interacting with recommender systems where their data is being used and also being served. Regulated. And also as well, we framed the project with the idea of there being a theory of change behind pieces of regulation we're trying to examine. So the theory of change is something which is used by policymakers to really identify the elements of the intervention they're making. So online safety laws or laws for policy intervention through legislation. They obviously need to think about the intended outcomes and impacts. What is this legislation and regulation intending to do? What is it expected to bring about in terms of change? So creating a theory of change is obviously a really important part of evaluating these laws, which obviously we all have really high expectations. So the focus again, as Sonia mentioned this briefly, is again to look at the EU and the UK. So the main focus of the regulation is the ADC Safety Act. That's not to neglect, some other important developments which are happening in other parts of the world. So, for example, in Brazil, hopefully, maybe in a future study, we'll need to include that law as that takes effect as well. But we selected those 3 jurisdictions, the most comprehensive and sort of advanced in terms of their implementations. So what we did for the study was we've got 70 platforms in scope. This part of the research that includes social media, gaming platforms, AI, which we identified through research on places where we know children are actively using these services and evidence where we know there are risks prevalent as well. We also looked at where regulators are currently identifying platforms as area of risk as well. And then we identified 70 platforms. We had 50 platforms in scope of phase 1. We used the same 50 again, and we added 20 new areas like it. We analysed these safety and privacy safety and privacy changes that these platforms were announcing. So they were putting the details of these changes on blogs, on press releases, on policy pages, etc. So we tried to identify all the information we could, which went into the public domain about changes these platforms. We also wrote to all 70 platforms. Sad to report that many platforms didn't respond. Only 4 platforms really gave us a substantive response. Some large platforms even cited the lack of resources, not wanting to respond to this. So therefore, we had to rely more on the information. Okay. Just to talk very briefly about what's happened in terms of the analysis. We've got a lot of data about these changes. We categorized them. By default, as I mentioned earlier, that proactive step that platforms take to put those protections in by default, things like live streaming switched off by default. Then we have tools. So those are end user tools that a user has to proactively activate. They actually have to do something themselves. Information provision to users, so are they alerted to something? That can be a safety measure as well. But lastly, support measures, for example, where children can go for help or support when they've perhaps got a concern. We've also this time as well introduced more subcategories within that. So we've actually done a more detailed data analysis as well. I won't talk about all of that today. Then this time we did something new as well. We've looked at all 70 platforms and looked at whether they had age assurance in place. I'm going to talk a little bit more about the data in a minute to try and look at the trends and to exactly see what's happening. We didn't have enough research budget to be able to do research ourselves, and we didn't have enough research to go and speak to children ourselves about how they're experiencing that. But there is some other research out in that particular area that I've sought to synthesize and analyze and bring into the research. We also looked at the evidence of the published risk assessments and audit reports which have been produced under the requirements of the Digital Services Act in the EU. Those have been published since the very large online platforms, the VLOPs, very large online search engines have been designated. So in 2023 or 2024, for some, they've been publishing those year on year. So I've done some analysis of what evidence. And lastly, of course, with my regulatory background, I've looked at what the regulator, what enforcement actions they take, what the guidance they produce. That sort of sums up the evidence we're trying to print. So just a very brief snapshot now of the research finding. A few things which hopefully may stimulate a bit of debate and conversation about some of the things we started to learn. So this set of data illustrates the difference actually we've got between the platforms here. We've clustered them together for Meta, Google, TikTok, and Snap. We did that in the first report as well, because that's where the largest amount of data was available as well. So we focused on those platforms as well, obviously, because they're some of the most heavily used. Right? We've got that data here for 2024 to 2026. And then we're looking at the other platforms. So out of those 70 platforms we looked at, we had 31 platforms where we found changes as well outside of Meta, TikTok, Snap. So I think what's interesting here is if you look at the categories I talked about earlier, so by default measures, information measures, support measures, and tools, you can see quite a distinction between Meta, Google, TikTok, Snapchat, and the other platforms. It's a much bigger push and growth or indication of the by default measures which have been implemented by these other platforms. Whereas actually, the Meta, Google, TikTok, and Snap, we've seen this shift towards tools rather than by default measures as being the leading area in terms of where they're introducing new measures. Of course, those platforms, as I'm going to talk about in a minute, have already put in place measures. So Meta, Google, TikTok, and Snap have been investing in this area for some time. But it indicates when we can look at the detail of these types of changes, because we can categorize, it seems to provide an indication platforms are shifting a larger group, major platforms, Google, etc. They're particularly placing this focus on their use of tools, which of course places that requirement on children or parents to have to take that active step to be able to get the protection. So, for example, some platforms such as Meta now have a mechanism within parental controls but allow the amount of time online to be set social media app, Instagram. That obviously has to be activated by the parent, and then we have lots of questions about effectiveness. So that's just something which I think starts to illustrate, but I suppose we've got a positive and a concerning picture here. Yes, we can see that you can see linkages between areas of regulation, even if it's not always explicit. The platforms don't always say we're doing this because of regulation X, they just do it. When it's age assurance, they often do say, well, I'm doing it regulation. But what we are getting therefore is a picture of, we can see there is change happening, and it's happening at quite a significant level in terms of these changes coming through, but obviously this graph is one which extends from the graph we had in the first phase. Okay, it's just for Snapchat. But what you can see there, that big curve and that growth in online safety and privacy changes being introduced by the platforms in 2021. What happened in 2021? That was when the age of 9 code. We were able again to be able to see that linkage and that impact, and also a continued focus through 2022 and 2023, the investment in by default measures. And therefore, this shows as well how we've actually seen, you can see it in a different way on this graph, growth of the use of tools by these platforms as well. It may provide us an indication, but perhaps these platforms are stopping at a certain point. Maybe their risk assessments telling them they don't think they need to take any more, you don't need to make such a large investment in by default measures compared to the investment. This is a complicated picture. Platforms are different as well, and some platforms have made, I would argue they have made significant investments. So for example, Meta introduced teen accounts last year. Just a little bit of information about age assurance as well, because it's something so many users are encountering and seeing online at the moment when they're interacting with services. Of the 70 platforms we looked at, you could see as well that, you know, a large majority, 46, had some form of age assurance in place. I didn't assess whether the age assurance was effective because I didn't have the technical time or resources to test that. It still gives us an early indication, and therefore we can see some had no age assurance in place. And then I decided as well to pull out where some just use self-declaration, which obviously is an effective form of age assurance. The other thing we learned as well was the diversity of different age assurance mechanisms that were being used. So you can see that on the graph there on the right. And obviously at the top there as well, we've got facial age estimation is now the most heavily used age assurance measure in these particular platforms. See. As well, it's worth noting as well that many platforms have multiple options, which is why you have the figures here. Obviously adds up to more than 70. So some platforms might offer 3 or 4 different options so users can select, and therefore they try to support the diversity of the user community as well. But I think what we learned about looking at the age assurance measures as well, though, was there wasn't a lot of information on the platforms themselves about what level of certification was in place. Have these age assurance measures been tested and verified and they work and effective in practice, and also preserve privacy? So I think at the early stages of learning about how age assurance is being implemented, these mechanisms are going in place, and they're often linked to age appropriate features for children. So if you think about the changes made on Roblox, the gaming platform, the age assurance is now linked to the restrictions on the chat features the child is able to. That's age assurance. So it just gives us a little snapshot of what we can learn from the data. Then the question of, are the changes effective? A really difficult question to answer, because obviously I didn't have the resources to do safety testing on all of the 70 platforms in scope. What I found from the evidence I could see is, first of all, and it's something that I think we know, a lot of us will know about, but it's still important, I think, to really identify and document it in this research. There is a lack of published independent evidence of testing from the platforms themselves. They're obviously not publishing this data. The regulators are calling for testing, but they're not saying what they're doing yet. Also, the DSA risk assessments and the published audit reports under the DSA in the EU, giving very little evidence and detail about what testing was taking place. Wow. And then the NGO and academic research I looked at, it wasn't obviously clear across the board, but we could always say certain safety features were ineffective. There's some significant prima facie evidence which indicates that concerns still exist about some of these measures. So like Meta's accounts, there's been research conducted by the Five Rights Foundation. Molly Rose Foundation funded a red team testing of Meta's teen. Roblox as well has been tested by the research organization Revealing Reality. And importantly as well, they've done before and after testing. They did that last year, which I think is a really important part of the methodology we need to see so we can get comparison. What this evidence does, where we've taken from these secondary sources, is it pulls together evidence where we can still see conduct, content, and cross-cutting risks still persisting in terms of what this evidence represents. So it tells us as well that although there are some positives in terms of these measures being introduced, measures still may not be addressing all of these risks, and when the measures are in place, we still need to actually have that verification about how they work in practice. Some of the platforms are publishing some information. So, for example, Meta have produced some information about their teen accounts and the default settings. So they argue that over 90% of users keep the default settings in place, but the teens are using them. The data they provide is so high level and so granular, it's very difficult for us as researchers to verify and understand what that high level data means. And it's obviously been published on their own terms as well. So we're starting to learn about effectiveness, and also this gives concern, therefore, about how much we can have in terms of a level of confidence about changes. Just very quickly to wrap up before we move to the discussion, to the new conclusion. The regulation is enabling new safeguards for children on a wide range of platforms. So we saw changes across a number of different types of categories of platforms. Social media, gaming, AI platforms, video streaming platforms, messaging platforms as well. So we are seeing an effect across a wide range. Already mentioned this as well. The major platforms investment by default protections has slowed and shifting. It appears to be shifting to present these. As I said earlier as well, significant concerns exist about the effectiveness of some of these measures, some significant risks. Then as well, a vitally important part which we have to address and is addressed in the recommendation. How do we improve transparency and evidence of independent testing? Then lastly, to the actions of the regulators as well. So I think it's important to recognize that regulation in this area is new, it's novel, it's complex, and it's taken some of the regulators time to get up to speed. But equally as well, I would cover and analysed in the report about the types of action, including formal enforcement actions in terms of either enforcement notices or business disruption measures or fines that have been issued. And it does appear that regulators have been quite slow and haven't been particularly agile addressing risks related to children, how they can drive change. Also, to take different examples as well, we've got concerns about the online safety children's codes in the UK as they're ambitious. In the EU, it took a long time for the Article 28 guidelines related to children to emerge. It didn't emerge until 2025, even though the DSA itself was approved in 2020. So how do we get to a situation where regulators are moving at pace, accordance with the risks? So that they've got to get things right, they've got to have legal precision as well. So it's a difficult challenge. But I think we do call out in the report some of the issues and concerns we've got about regulators. I think the positive point to point to in the research is 2026 does show evidence of a step change, particularly from the European Commission in terms of the preliminary findings it's made against Meta and TikTok. So, lastly, as well, the topic of AI platforms is covered in the research as well. So AI platforms are starting to introduce by default protections. So you can see those, for example, from character.ai on ChatGPT, OpenAI have introduced a number of by default measures. So we're starting to see these platforms introduce these protections. Obviously, it's the most emerging area of concern at the moment, and the new and novel risks that emerge from children on AI chatbots. But equally as well, we have a number of gaps in regulation. So we might have gaps in terms of the coverage of the Online Safety Act, AI. we're not 100% sure what's driving the AI platforms to make these changes. And obviously there could be a risk the platforms themselves start to set the norms rather than the regulators. So that's the conclusions of the report. I think as well, just to finish off, I think I would say that the evidence from this report means we should continue to significantly invest in regulation. We shouldn't give up on regulation, in spite of all of the concerns which exist about risks to children online. But we've got to make it work better in a number of different ways. Clarity of the regulations themselves, how they're enforced, what research and evidence we've got, and all of that needs to come together in a particular package. And lastly, as well, to of course recognise all of the other work the DFC does, voices of children needs to well. I'm just going to put the recommendations up there as a prompt because we're going to discuss that on the panel because I know Beacon's going to get into that topic. But just to highlight, recommendations in the report are broken down into categories for governments, policymakers. So how do we actually need to change the regulation itself? What do regulators need to do differently? What do the platforms need to do differently, importantly? What can we do as a research community in academia? So I'm going to finish there. I've probably gone on a little bit too long, but
thank you very much. Thank you. And I'm going to ask Steve to come and sit down, and I'm going to ask our three respondents to come and sit down wherever you, goodness knows which way you might face, but
where you go.
Take it. I don't. Yeah, I can sit here. Yeah. The report is well over 100 pages, and it contains everything you ever wanted to know about what platforms did in the last few years.
Plus there are two appendices as well.
Yes. So I'm going to pass to Laura. To start, I'm going to ask you to
okay.
Yeah.
I've actually read the report. I thought it was really interesting, and the concern about the slowdown matches a concern I've had about the drafting of the Online Safety Act, which I think snuck through at the time. For people who don't know, the Online Safety Act sets down some frameworks, duties for regulated service providers, which follow a risk assessment, risk mitigation model, but they're set down in the Act at quite a level of generality, with one or two exceptions. The obligation to put more detail then falls to the regulator Ofcom, which then puts Ofcom in a very responsible position. Now, the problem is, in the Act, there is a provision that's been referred to as the Safe Harbour provision, which says that if a company complies with Ofcom's codes, which are not mandatory, if the company complies with Ofcom's codes, it is deemed to have satisfied all its duties that the code relates to. And the problem here is that Ofcom's codes are quite minimalist in what they've required. Now, I think part of the reasons for this is the need to understand solutions and looking at the research that has been done. A lot of it focuses on the problem and not on how we might get to solutions. And so Ofcom has been hesitant to impose obligations that might not work. It's also taken a view that it actually has to be quite specific as to the terms of the codes. So rather than putting a programmatic obligation in, which says where you've got a risk assessment, consider how you might respond to it, have a process in place to do that. It's instead just specified a limited number of obligations. And it may be, though I suspect you couldn't prove it, it may be that this has encouraged companies to do implementation to the level of the code. I should point out, though I don't want to steal all this thunder, that the DSA doesn't do this. They've got risk assessment, risk mitigation obligations for very large online platforms and online service search engines, but it doesn't have a safe harbor provision. So there's an interesting question as, is there a difference between what happens in the UK and the EU on that? I think Steve's points around a shift from default tools to end user tools brings us also into the debate about safety by design and whose responsibility it is to make things safe. I think at the moment Ofcom's thinking it's responsible to determine everything about safety when it should, in my opinion, be the obligation of the platforms, a form of product safety. And the Act does say, Section 1.3, my favourite section, that services should be safe by design. Unfortunately, we don't have clarity as to what that means. And I think, though, we'd probably require statutory changes to do it, that it would be good to have principles about what a by design approach means. Because we've got safety by design, we've got privacy by design, we've got security by design. What does it mean? Now, I've come up with 3 thoughts that sit on a basic principle. And the basic principle is the user should not be made solely responsible for ensuring their own safety. That's true for everybody, but it's particularly true for children. That comes from the UN Business and Human Rights, the Ruggie Principles. The 3 aspects, if you like, of safety by design are think about the life cycle, so the development, the deployment, and the retirement. Think about the entire product. So if we're talking social media, how do users access their accounts? What tools do they have for the creation of content? Discoverability, tools for engagement, like likes and upvotes and the like, before we get to moderation and those sorts of tools which come in at the end. And then the third is the hierarchy of control. And this we see in building regs and chemical engineering, which is design out the problem first if you can, and then move to mitigate. Now, obviously, that's quite difficult because, as Sonia pointed out, there's benefits as well as disadvantages. Not everybody is the same. You've got different groups of users, and safety may be relative. But you should at least be reasoning about this and thinking about how that happens. So that, in a way, is a gap in the Act. I think Ofcom could do more. I think it's within scope. The Online Safety Act Network and a whole bunch of other civil society organisations, including Five Rights Foundation, have suggested that it is within Ofcom's remit to do a code on safety by design to cover this. But as yet, we haven't seen anything. So I've probably rabbited on for my 5 minutes. I'd like to end with a couple of questions, maybe designed to prod my fellow panelists. One for Sonia, what is evidence? What evidence should we be looking for? I agree that some tools are about defaults as opposed to end users, but I don't think that covers the full panoply. It's quite a good heuristic device to make to make the comparison, the contrast. But what about nudges and tools to add friction, questions about monetization, those sorts of questions. So is that enough? And to what extent is there malign implementation going on? This is my suggestion, that companies are going to the base level of the code. Or when things are uncomfortable, and Steve did point out that companies were pointing to age verification requirements when they received criticism about age verification rules, sort of playing a publicity game around law and regulation. And then finally, a question: is age verification part of safety by design, or a mechanism by which we might avoid dealing with safety by design? Because if children aren't there, we don't need to bother.
I'll follow my question later, but that's great.
Thanks, Sonia. Lauren, I have no questions for you yet, but I'm working on it. So thank you very much for the invitation to participate this evening. And I had the opportunity to read the report, although I did not read the appendices in advance. I found it's just incredibly useful to have this kind of systematic mapping of all of the evidence of what is proving to be effective or ineffective, kind of presented in such a kind of a clear and comprehensive way. And, I suppose before I go to the comments I wanted to make, just to pick up on the by design point, I was kind of reflecting as Lorna was speaking there, that if we think about, if we go back 10 years ago, the GDPR was just adopted 2 years before it entered into force. And it was the first time we had these kind of by design requirements in law. And I guess with my background as a kind of competition lawyer, thinking about economic regulation, at that time, it was really anathema that you would have regulation that went straight to the design of business models of companies. That was looked at as a very kind of interventionist move. And it was very rare, in the kind of regulatory toolbook. So I know we might have seen a kind of a slacking off of the implementation of by design features in the last couple of years between report 1 and report 2. But actually, I think on the whole, the fact that this is so clearly embedded in these regulatory frameworks now and central to them is in fact quite an impressive achievement from a regulatory perspective. Of course, then this brings us to the question of how we render them more effective. And there were 3 kind of themes that I wanted to pick up on, which kind of go to broader themes in digital regulation. So the first is, what do we mean by effective? And how do we measure effectiveness? And I think this is a question that comes across really clearly in the report. The second is, what is enforcement? And that might seem like a very stupid or simple question, but that is still very much contested and a live issue for regulators. And the third is around kind of transparency and access, which is, I think, another theme that comes across clearly in the report. So thinking first about what we mean by effective and effectiveness. We have case law from the Court of Justice of the EU in the data protection context, for instance, saying that a lack of compliance with the law doesn't necessarily mean that there is a harm to rights in a way that triggers damages. And I wonder if we can also say then the converse, that compliance with the law doesn't necessarily mean that you have an enhancement of rights and effective rights protection. And this is something I had dealt with in some of my earlier work, where you see that actually, particularly in these legislative instruments where you're regulating for rights protection, it's very difficult to find a metric which acts as an appropriate kind of benchmark for when we have kind of effective protection. And I guess what emerges clearly from the report is that compliance does not equal effectiveness. And you see this kind of disconnect in the audit reports for things like the DSA, where the companies are able to demonstrate compliance, but they're not able to demonstrate or are not demonstrating explicitly in those reports that the measures taken to comply are in fact enhancing rights and protection on the ground. And this, I think, is kind of a broader kind of theme in digital regulation. So Helen Dixon, the former Irish Data Protection Commissioner, who was very much in the eye of many storms about GDPR enforcement, wrote a guest editorial for the journal International Data Privacy Law, where, and this is very recently, entitled "GDPR is not loved, but does it work?" And what she says is, what a good outcome for GDPR regulation would look like in real terms remains obscure, as do the mechanisms by which such an outcome might be achieved. Is it time to accept that a law this broad and all-encompassing requires an equally expansive, well thought out and objective system of evaluation? And I think this very much kind of aligns with one of the kind of key themes that come across in the report. The second thing is, or, one of the reasons why we have this focus on, when is regulation effective, is because we have a discussion about what is appropriate enforcement. And here, with a lot of these regulatory instruments, if I think about the GDPR and data protection in particular, the focus has been on fines. But you see, and I think Steve mentions this in the report, that if we looked at something like the Irish regulator, they have imposed over 4 billion, like 4.04 billion in fines since the GDPR entered into force. So that's not a small sum. However, 4.02 billion are currently unclaimed or in some sort of escrow because of litigation that the regulator is caught up in. So this, I think, puts the kind of question of a kind of a regulatory thicket or a litigation thicket on the table, which is a particular problem in federal systems, included in that something like the EU, where you have delegated the act of enforcement to national regulators, and then you have input from European level regulators, and then that goes back to a national regulator. You create multiple points for contestation and for litigation. And there is the kind of lawfare technique used by companies to challenge at every possible intervention point in order to slow down the process of enforcing the regulation. Now, there were some lessons learned, I think, in terms of the design of the DSA, because you have VLOPs and VLOSs, whatever we're calling them, enforced. Their regulation is done by the European Commission. We still have this question about fines. But what then is the alternative? And I did note that the report is fairly open to the idea of regulatory dialogues or regulatory conversations. And it actually provides some very useful examples of where these kind of regulatory dialogues with regulated firms have led to kind of effective change. And so there's some evidence there of the ICO leading to kind of a change in this context. But I did want to kind of bring into the frame the kind of risks of regulatory conversations, or at least think about when they might be appropriate and when they are not. And, if you look at the work of somebody like Julia Black, former LSE scholar, you see that her work kind of points to the idea that where you have repeat offenders, kind of systematic offenders, or where you have a large asymmetry of power between the regulated and the regulatee, then these regulatory conversations are inappropriate. I think I'm being asked to wrap up. We could think about regulatory enforcement in the UK on the ICO. Happy to think about that or talk about that, but I'll just move to the last point, which is transparency and access to data. I think this is on two fronts. First of all, the transparency of what regulators are doing. And you can see in the report, it's mentioned a few times that we don't know what information the regulator has sought, for example. But also when you look at things like the DSA, Article 40 gives vetted researchers the right to access to the systems and the data from regulated entities. And we're just now seeing the responses to those first requests for access to that information. And Catalina Guanta, one of the leading researchers on the DSA in Europe, has a kind of a nice write-up of some of the challenges of this, which maybe we can talk about. Last thing I would say is, and I've been thinking about this a bit, and I think it goes to Lorna's last question. If the protection of children is a subset of the overarching regulatory framework? Is this kind of the canary in the coal mine, insofar as if this, the element of digital regulation, which is perhaps least contested, is being so ineffectively enforced? What does that say about the rest of the regulatory framework for others who are not in kind of a privileged position in terms of the regulation? And as a matter of strategy, and I think this would be a question for Sonia, for Baroness Kidron, is the strategy then to focus on the overall effectiveness of the digital rule book as a whole, or to push more on the rights of children, as that is in some ways the politically least contested area of digital regulation?
Yeah, no, well, thank you very much. And I wanted to just start by saying how very important I think the report is for bringing this together and for making this what is really a valiant attempt, given the lack of transparency. And I think that we have to just put that in perspective and say that lack of transparency, in my view, is the political reason for regulation. Right? That actually there is no appetite to make this work. There is no appetite to really come forward and make children safe. And I think that I'm going to say at the end of my remarks some pretty aggressive things towards our regulators and towards our governments, about why it is not happening properly. But I wanted to first to just talk a little bit about the recommendations that Steve has made. And I broadly agree with all of them. But I would say that they are highly operational. And in that sense, they're really useful, because if you were a regulator, you could actually look at this list and make some fantastic changes almost within the powers you have. If you are a government looking and saying, why the hell is this not working? Yeah, you could actually take some things off this list and go fix it without new legislation. So I really want to commend you for what sounds like a narrowing of your purpose, but you do have a regulatory background. You have been very careful, and I actually commend the list. No, you should. No, I commend the list to everybody in the room, to everybody online, to look at it in detail rather than just as a general thing, which is all that I have time to do, to say that on the whole, the recommendations are go upstream, test before you deploy, broaden out, cut out the carve outs. They are absolutely practical and sensible in that regard. I think in certain places they're very courageous. You say get rid of safe harbor. That is actually skewing where we are. You say actually we may have to go to business disruption. If the reason that the problems are here is because of the business model, the only way to tackle that is by disrupting business. That gets us to the table. Yeah. So I might have written some of them more robustly, but that's my part of this equation. But I absolutely think they are all in the right direction. And I think that the other thing that I was perhaps surprised to see you reach for, not as a negative thing, but as a positive thing, is that actually you mentioned private litigation a couple of times. And I think that that is something for those of us in Europe to really think very hard about. We are seeing what's happening in America. We are seeing that the litigation is actually not only creating possible changes to design, not only getting quicker to some of the levels of fines that we would like to see that are not in escrow, but I think possibly the most important thing about the private litigation going on in the States is the disclosure. I have found out more about what is going on inside these companies, what they know, how it's designed, from reading the disclosure documents, which I can tell you gives you a headache. I mean, they are so difficult to get through and to get to, but they are absolutely to the point. And I think that all of us who do care about this area of regulation have to look at the history of what happened with smoking. It started off being personal choice, and it only changed when it started to go to how was it designed, what did you know, who knew, when did you know? And that is what those are happening. So again, I was really pleased to see that coming into your recommendations. And then I'm going to make a sort of a funny observation, which is that actually, you know, your recommendations to the platforms, you showed us that they were in 4 categories. There was a lot less recommendations for the platforms than there were for civil society, for the regulators, and for the legislators. And I think, again, that's a signal of lack of faith, or lack of good faith from the regulators, that from the platforms, from the companies, that you do not believe that they are going to act without a push. So that's how I respond to the regulations, but to the recommendations. But I really do urge everyone to actually look at all of them. There's a number of them, and they're worth a proper look. I wanted to just pick up very quickly on the broader context, therefore, yeah, which is to say, you know, I'm very concerned about the questions of the report. I would have renamed it. Does regulation work? Yeah. Regulation has to work. Do we have the right regulation is a different question. And I think that everybody has been contributing to that question. But I think that I want to say the things that are outside the envelope of what Steve was looking at. There's nothing about treating tech, big tech, as a utility. There's nothing about public control. There's nothing about competition and antitrust. Yeah, there's nothing, and I'm not saying there should have been. I am just saying, when we ask questions about regulation, please do not ask only about whether what we have is working, but whether we have the right regulation. So that's my first big point. My second big point is about the regulators. And again, I mean, I know that you come from that world, and I suppose what I should say, declaration of interest, because it wasn't in my introduction, is I was the author architect of the Age Appropriate Design Code. And I worked with Steve when he was at the ICO, and I had to lobby him quite heavily. So yeah, exactly. So we go back a bit. And I would say this, that I would also put on the table leadership of the regulators, capture of the regulators, and political will behind the regulators, because we saw a change in the ICO when we got a change of leadership at the ICO. The ICO, part of that spike over there was actually the ICO, where you were there, when Liz was there, was absolutely behind the AADC. They didn't want it in the beginning, but once they got it, they put everything behind it and made it a primary priority for them. It is my contention to the room that if we were more serious about GDPR, if we were more serious about privacy and more serious about the AADC, a lot of what we've seen since would not be necessary. Yeah, the content stuff. And let me finish so that you do get some questions in, which is to finally say that the failure, if you like, the failure of competition law gives you data law, the failure of data law gives you online safety law, and the failure of online safety law gives you bans, right? And I think that this is what we have to say. It is so serious, the failure to really enact and risk and put political and power behind it. And I've got one further recommendation to add to your list, practical one, which is, I think, where there is an absence of evidence, that should be seen as wrongdoing. That is to say, we have to turn around this question of transparency. And instead of keeping on mandating transparency that we don't get, is where there is no transparency, we should assume that it's not working and do it that way round.
Provocations, a lot to think about, a lot of expertise, I think, has just been shared. And I know there'll be many opinions in the room and online. I'm going to suggest that we move directly to questions because I'm looking at the time. And given the bizarre nature of this room, I'm going to suggest we take a few questions on this side of the room if I see any hands, and then I'm going to come to the other side of the room. If anyone has questions, would like to. And there are some online as well. Yes, I think Kim is going to bring in the ones online. Okay, while everyone is thinking, should we start with online? And Kim, please, yeah.
Okay, I'll start with two from online. The first, so these questions I'll pose to all of the speakers. The first is from Stefan Halk in Norway. Do you have any views on the resources, budgets, etc., that are allocated to regulatory bodies? Does it keep up with the presumably large number of issues and cases the regulation themselves stir up? And the second question is from Vaughn Baltimore from Virginia Tech in the US. Questions for all the speakers. How do regulatory interventions reshape the algorithmic cues adolescents receive?
Wow.
So the second question is about how regulation can, or if it does, reshape the algorithmic cues, so the algorithms that shape what, or adolescents' online lives is what I'm reading into it.
It's like the obverse of safety by design and privacy by design has become exploitation by design or algorithmic manipulation by design. So are we getting to that? Yes. And are we giving enough budget? I once read that the ICO in Britain has 100 times the budget of DPAs around in many other places in the world, even across Europe. Whether more budget brings more effectiveness. Liban is looking like, yes, go for
Well, no, on the budget question, this always comes up in Parliament. So obviously one needs a good budget, but what one really needs is the backing of government for lawfare, as we heard it. So to take risk and to not be risk averse. But I think that actually it moves more towards a combination of my recommendation and many of Steve's recommendations, that we automate the fines, we automate the business disruption, we automate the need to be transparent, rather than have these complex. I mean, the code, the children's code that Lorna talked about, is 1,300 pages long without the appendix. It is a gift to a $1 trillion company, and it is really, really difficult for civil society, or indeed for the regulator, to hold the line. On the other question, just very briefly, I think that the answer to that question about algorithms is yes. If certain things are disallowed, then it changes the algorithmic power. And I think one thing that we might, since we are all quite critical of the Online Safety Act, one thing that I would say out loud and in its favor is, you know, when I started doing this, if I had turned around to a room full of people like this and said, do you know what, there will be a time where you're not allowed to routinely send pornography, self-harm, you know, suicide ideation to under 18-year-olds in this country, and that will be the law, you'd all go, nah. Yeah, I mean, literally. And now that is the case. And that is algorithmic design, if you like.
On the question of budgets, if you ask a regulator, do they want more money, they'd always say yes. And I used to say that when I was at the ICO. I think as well, it's important to think that there are different funding models for regulators. It doesn't all have to come from government. You've got regulatory levies as well, so there are different funding models. This obviously has to come down to, though, a risk-based approach from the regulators, but it's important that they get that right, they consult on it, and it's transparent and upfront. So that, you know, there's a chance for research input, evidence, etc., stakeholder engagement about what they think the most important risks are and what they're going to obviously ultimately address and put the most resources towards. So I think thinking about that particular context can be really important. I think the other aspect I'm still interested to explore would be the context in which regulators often have to act in terms of, you know, the legal uncertainty that we've talked about, and the concerns that, you know, you're going to be perpetually consuming millions of pounds of your regulatory budget in legal disputes. And I think it comes from having the balance right in the clarity of the law, so those grey areas aren't too grey. And also, of course, there are some things in online safety laws, like in the DSA, there is a prohibition on behavioural advertising to minors. That is a black and white thing. Have the platforms addressed that or not? Yes, there are some evidence to gather and you can do it. But so there are certain things which are clear, which regulators should be able to enforce reasonably directly and swiftly. But we do get into some more difficult areas, which the Commission is starting to enter into with TikTok, in terms of whether the functions and features are addictive, which obviously are going to require more resource to research and evidence. And that's going to be a really pivotal moment for online safety in terms of how the Commission advances that. But equally, of course, if regulators can get these lead cases right, then it sends a message across the market. So that's the challenge for the regulators, to sort of get all of these things into balance. The last very quick point I would make as well is, I mentioned it briefly in the report as well, I think another positive is some of the regulatory convergence we're seeing internationally. So the fact that you can see the same message coming from the UK, from the EU, from Brazil, Australia is doing a children's code now, Canada is planning. I think that all creates a global leverage and an indication of this is what all of these different countries around the world are focused on, I think is helpful as well. And that should, as well, I think, in terms of technical standards, not just the regulatory guidance, technical standards around age assurance as well, a global approach to that, I think this helps create more leverage. So regulators have got to work and cooperate internationally as well as part of that. So that is where some of their money is going to have to be spent.
And it is interesting that the Commission had started with addictive, with TikTok. Thinking also of the Meta case in California, which similarly has attacked the addictive algorithms, whether it brings about change in the algorithms. And to Lorna and Orla.
Resources, well, yes, it is all about how big a bucket you want, but I think it is important to recognise the impact of lawfare on both regulators' budgets and therefore their choices. But they're never going to have enough money to do all of it. So it does come down, as Steve says, to priorities. And those who are interested in Ofcom, I think they published a list last week of what their priorities are going to be, because I think they've been pushed around a bit this year by events. She says darkly. The algorithm, I mean, in principle, the Online Safety Act could cover this. This comes down to, I mean, it is mentioned, algorithms are mentioned in the Act. Certainly they have to be considered in the risk assessment. But I don't think we're at the stage at the moment with Ofcom codes where Ofcom is requiring a fundamental rethink of those algorithms. It is more looking at put tools in place so this sort of content doesn't get pushed, rather than thinking, you know, how have we designed this? What are the weights? What are we valuing? So it is still, although looking at the role of these tools in framing the online environment, I don't think Ofcom has got back to the base question of how were they designed in the first place. And just going to addiction, more difficult for Ofcom because although as regards the children's duties, there are some references to addiction. Fundamentally, the Online Safety Act is about harm from content, not use.
Thanks. Maybe if I just say something on regulatory resources, because I wanted to kind of highlight earlier that David Erdos in the UK has done an incredible kind of mapping over the past 6 or 7 years of the regulatory action of the ICO. This is not to pick on the ICO, but the numbers are really quite stark. Last year, there were 2 fines, no enforcement notices, and 3.8 million, 2 fines with 3.8 million of a monetary total. And that's just paltry. And he compares that then to the resource available to more active authorities in Europe, like the Spanish or the Italian, who are working on budgets that are somewhere in the region of 400% lower than the ICO. So I think this goes to the point that was made about, the appetite to make things work. And that's about, signalling that you are serious about enforcement. Because I think if you speak to some lawyers in the UK, they say, realistically, when speaking to clients, if the risk of enforcement is 0, then that's tricky.
I just want to say about that is that also the regulators in the UK have a very little appetite for publicly shaming the people who they're dealing with. And so that means that you can sit there until they come for you instead of actually, spreading, instead of raising the floor. So this is not allowed and it won't be allowed on any platform. They go one by one by one. So it encourages people to come to wait and see.
And we have had 20 years of working with the platforms through self-regulation to see if everyone would play nice and make things better. So I think that legacy is kind of still there. Okay, I'm looking around at the room. If anyone has, yes, and you and yes, please, and then next, and someone on this side, maybe. Okay, yes, okay, 2. Okay, so let's take 4, and then we'll have a round because I think that might take. Yes. That's a jolly good question. No, I'm going to run in your direction. Because otherwise you're online. You can use it. You can use that.
It's very well by those actually, but is AI sort of ever waited in platforms? But different coverage of AI within the platform. Fundamentally, it's not it or like where do we like cover it or legislation and progress.
Brilliant. Thank you. So yes, we're all pivoting to AI and it's many times.
I should have said, please press the little button on your thingy and say your name and affiliation. Sorry.
Hi there, Dervla Nick Ward from TU Dublin. I'm just wondering if the overall regulation and attempts to, I suppose, avoid harms or difficulties with children's rights, is there enough specificity in our understanding of what those harms are or how they are operating through digital mechanisms at this point to be even more specific in our regulation and therefore have more clear things to point at when engaging with the tech companies and indeed with people that are looking after children?
Hi. First of all, what an amazing collection of people to have in one room. I think we're really lucky. So I really admire the work. And I am reminded in terms of the conversation you just had about regulation, that a good friend of mine, David Evan Harris, describes tech companies' attitude to regulation as being the same as a group of hikers who spot a bear in the woods. And it doesn't matter as you're running away if you're first or you're second or you're third. It only matters if you're last. So they do the minimal not to be last. But it sounds to me from what you're saying that actually they will just amble away and not give a monkeys. But behind that anecdote is my question, which is, I am a believer in regulation. I'm ex-Ofcom. I helped write the Digital Services Act clauses we've been talking about. But I am aware that I and organisations such as myself are losing the battle with parents. They don't believe in us anymore. They don't believe in regulation. They want a ban. And we can say till we're blue in the face, well, that hammers through children's rights. It lets the tech companies get off the hook. But the focus groups that I'm with parents are saying, yeah, but, you know, if somebody's selling heroin to your kid and you're saying, well, we should have a less addictive form in about 3 years' time, I just want to ban. And I think that would be retrograde. I just want to put to all of you amazing people, how do you talk to parents, give them hope that the changes that Steve is talking about are real? And how do you do it fast enough to keep them on board?
Great question. Thank you. And last question. Yeah.
Hello, my name is Divya. I work for the Raspberry Pi Foundation, so on the platform side. And I'm curious, we're thinking about it very seriously about how to develop safe and responsible products. And I've seen some criticisms around the fact that an emphasis on by design frameworks can be a bit techno-solutionist. And how can we, as a platform, be thinking more holistically beyond just by design? What might we be missing?
You could vote, I think. You could.
Well, I can go for the first one actually on AI because we do address that in the report and in some of the recommendations, and it is a really difficult question, and I suppose it links to the second question as well about how much specificity do we have about our understanding of the harms, and obviously some of the harms relating to AI, children, relationships with chatbots are starting to emerge. I mean, groups like the DFC are already trying to do research on this and trying to look at these issues as quickly as we can. But obviously, what we can see from some of the evidence, which I have pointed to in the research, some of it's conducted by NGOs, is obviously there is some evidence of this, obviously going on to AI platforms with like a child-based avatar and seeing how that platform reacts and the types of information that the chatbot provides. I think we're still in the infancy of that, and I think it's probably got to get a lot more sophisticated. But I think we're already sort of seeing some quite strong prima facie evidence. But I think the biggest concern about a number of the AI platforms was that initially they were launched with really hardly any guardrails for children at all, and it's only now that some of them are catching up. I think some of them are now sort of making some quite serious statements, and they're detailed in the reports and the changes from OpenAI, Character.ai, Replica, Claude. A number of these platforms, Google have done it for Gemini as well. There are a number of different safeguards coming in, but I think my concern is that we've got these gaps in regulation, so they could be defining the norms themselves. Data protection law applies to AI when it's processing children's personal data. So we've already got areas where we can address, like, are the prompts and the child's interaction going back into the learning from the model, or how does all of that interaction with their data work? So we've already got some areas of regulation. Lorna's done quite a lot of work on where the OSA applies or doesn't apply. Of course, you've got the AI Act in the EU, which covers rights broadly. So one of the recommendations I make in the report is that the AI office in the European Commission, obviously one that play a key regulatory role under the AI Act, issue guidance about children's rights in AI. So we've got some levers I think we can start to engage with. But I think I could link all the questions up actually. I think to go to the third question as well about parents and how do we move quickly. There's no bigger example than that from AI, with people just feeling that it's just moving ahead at such a rapid pace. So how are we going to introduce an agile form of regulation that actually has that confidence of the wider public and parents and children? But policymakers really can't take too long on this, which is difficult because they need research and evidence to feed into it to make the right decisions. But it's got to be done at a certain pace.
I'd like to push back on this idea we need specificity of harms. The idea behind safety by design is you look at your product and have a sense of what the consequences are. When I was involved in the online safety bill process, I gave the example of health and safety at work. If you were doing a risk assessment for health and safety at work, you wouldn't go, big toe. How do we stop people stubbing their toes? Okay, done that one. Broken leg. Something more serious. You just wouldn't do it. You would look at the environment and say, there's a light out at the top of the stairs. Someone could trip over that loose cable and go down. You'd have a sense of the harm. You're not just sort of abstracting it from harm. But I think focusing on proving the harms is reversing things. You should actually be looking at the product. And Steve mentioned product testing. You should be thinking about this.
Which means, in effect, thinking also about the features of the product or the affordances of the product,
Yep.
and what risk they pose.
Yes.
What harms actually, because as the social science researchers, it is so hard to be tracking all of the harms that are going wrong. So much is going wrong in children's lives, but the risks linked to the features and
are much more manageable.
Paula, is safety by design too technocratic? And
well, I'm going to pick up on the last point you were just discussing, if that's okay, just for a minute, because I completely agree that, you know, we're thinking about the affordances of the system and then and kind of trying to mitigate risks. But within this, I do think it's hard to kind of totally avoid thinking about harms or damages completely at the back end, because again, when we're thinking about measuring or benchmarking, is something effective? It's effective against what? Like, did it make things safer for children? Did it, you know, you're immediately into that realm of having to somehow define. And then the second thing is we've talked, or, you know, alluded to the idea of private litigation. And in the UK, for example, and elsewhere, Ireland and other places, in order to successfully sue for damages, you need to show harm. And we have case law from the Supreme Court in the UK saying that breach of the law is not in itself evidence of harm. You have to be able to similarly be able to show those damages. So, you know, I do still think there's something to kind of muddle through there. On the parental ban, I agree. It would be. I agree that would be retrograde. And in thinking about how to discuss this with friends and colleagues, I think one query is around enforcement, because if enforcement is a challenge generally, then it will also be a challenge in this context. And then, of course, as others have spoken about written about far more than I have, but I think this goes to the last point I was making about, are we concerned only with children or with digital rights in the environment anyway? Because what happens then? A cliff edge at 16, you're suddenly exposed to a world where, you know, as somebody in your 20s, 30s, 40s and onwards, you were also exposed to these risks. We might just see that children have particular vulnerabilities because of their development, but it's not that those risks completely disappear as you age. And so I think that then leads to a different kind of challenge from a parenting perspective, which is trying to prepare somebody for an environment that they've never been in and describing it to them in the abstract. The techno-solutionist critique is really quite interesting. My take on that is that it's not, I wouldn't take that as a serious challenge to the introduction of kind of by design requirements, but it's saying, I read that as saying, simply because you've introduced by design requirements doesn't mean that you know, children are flourishing, for example. They might need interventions beyond technical solutions in order to have a lovely childhood as they deserve. And so, yeah, I don't take that as a kind of serious challenge to kind of by design solution.
And can I just, sorry, I was just going to say what she said about techno-solutionism. You know, you can't say by design is a silver bullet, and you can't solve all of society's problems for it, but you might make things a little bit less bad.
will not reassure parents, I have to say.
I'm going to try and deal with the parent conversation, but before that, I want to just really properly agree with this techno-solutionism point, because I think the point for all of us is about human flourishing, about children flourishing. Raspberry Pi has a fantastic opportunity to make a contribution in this space because you have a different model, different business model. And so in a funny way, it's as you can do by design as imaginatively and brilliantly as you can think. Yeah. So it's really about who do you ask and how do you think collectively to find the best possible space. And I do think, and I just make a sort of a slightly similar point to all us here, which is, you know, do not think about taking things away from people unless you're thinking about what you're also going to give them. Because part of the problem is you take away the park, you take away the ability to go in the street, you take the ability to go to a friend, you take you take away the house phone, and then you take away the smartphone. You go, hang on a minute, I can't go out. I'm not, I have no one's phone. So we have a bigger problem. But at what point childhood became an absence of harm instead of a right to grow and flourish is an absolute disaster as far as I'm concerned. On the final point, on the ban point, I slightly made this case already, which is it is our failure that means that parents want to ban. And in the big battle in Parliament, I made a number of speeches against a ban, but voted for it. And I absolutely do agree with parents. I mean, what I kept on saying, and I'm glad to say that I've begun to hear it coming back at me, is, we have to make access to children conditional. The ban is on them, not on the child. And I do think that parents are desperate. We have failed parents, and I myself have put forward things for chatbots, for risk assessments, for different enforcement, for injunction, for individual redress mechanism. And this government in the UK has pushed back on all of them. So actually, if that's what politics are doing because they're in the pay of Silicon Valley and the regulator has no political oomph behind them and is risk averse, then actually that's where we end up. So I think we have to see it as a collective failure rather than as parents have got it wrong. They haven't got it wrong because they don't have 3 years. If you've got an 11-year-old, you want it now. And I think that really has to be in our minds. And that's why, some of this sort of funny conversation that we began to have about evidence, we don't have transparency. The people with the evidence don't want to know, don't want us to have it. Yeah. So why are we working at such a high bar of evidence? Yeah. In order to make the change? Why are we waiting? Why did the government say it's going to take 2 years to work out whether things are addictive while everybody's sitting on the tube like this? I am sorry, at a certain point, we have to decide the world we want and regulate for that. And if we make mistakes, they've done a lot of minimum viable products. Let's have some minimum viable policy and change. And that's the last thing I want to say is Albanese, for all his mistakes, the one thing he did was when he brought in the ban, he brought in the ability to change as he learned. Yeah. And we'll see what happens. But I do think that is part of the regulatory package, is the ability to be wrong.
There is, thank you. There is so much more we can talk about. I'm noticing at the GFC, we have a project on EdTech, and I'm noticing that some of the conversations about safety and privacy and phones, smart social media in children's home time is now spreading into the classroom. And there's a kind of call to take tech out of classrooms, which is taking us in a new debate. I'm interested that we haven't said so much about age assurance, because I know there are circles where that is a huge issue, and I've been told is going to break the internet as we know it when everyone is age assured to access things. On the other hand, how else do you know who is a child if you don't ask their age? And I'm interested that, we've reached a complex point, and the public is definitely frustrated. We have not offered solutions, I think, that are going to be fast, even though Steve has come up with some brilliant recommendations that could be enacted on tomorrow. The political will is beyond all of our control, except possibly B-bands. We have some Australians in the room, and we are watching very closely for everything they can say. And at some point, we did get also to a question that I think is another kind of collective failure, which is, I don't think as a society we have a very positive vision of how children can flourish, how they can live in a digital world. The DFC's kind of get up in the morning question is, what does good look like? And we keep documenting what bad looks like, and it's jolly hard to say what good looks like in this world. But we've reached the top of our hour. I want to very much thank everyone online for their patience, especially if we didn't come to all their questions and we can't offer a drink. I want to thank everyone here in the room for attendance and participation. We had some fantastic panelists. A very special thank you to Steve for what has been, I know, quite a lot of work. And a thank you also to the DFC team and to Five Rights and to everyone who was involved in making this evening possible. Yeah.